It's a sheer delight to actually address a live audience for the first time in 2 years and be back at Bowman's in that time. And, I was just thinking about it in terms of what Derek said. So much has happened in the last 2 years in relation to competition law as a whole that it's kind of difficult to try to reverse all of this in the context of one speech. You'll forgive me, perhaps indulge me, just 1 second before I begin. I can't help but not note this. Of course, when I was last here to speak at the Bowman's conference, your chairperson was Robert Lee. And Robert was a friend of mine and somebody that I had the highest regard for. And it sort of weighs on me today, if I may say so. And can I just say one thing about Robert, which in honor of him, which is not entirely irrelevant to what I want to talk about generally. Throughout my period as Judge President of the Competition Appeal Court, which for some seemed to be interminable, and for me was, because it was over 20 years, one of the things that I noticed quite early on and gave me greater and greater anxiety as the years rolled on was the issue of briefing practices. And whilst bearing in mind my own categorization of demography, I'm hardly against white men, it did seem to me that there were other groups in our society, to put it mildly, and it was really a great deal of anxiety to me that continuously we hardly ever saw any black counsel, any women counsel. And over the years, because I've taught competition law since its inception in 98, and indeed even before then, I obviously know that many young women and black lawyers, black women lawyers as well, had passed through our ranks and the ranks of other law schools, and that some of them had gravitated to the bar. And quite frankly, unlike a number of the white men who appeared in front of me, I stress not all, and maybe not even a majority, but these people did know the difference between a supply curve and a demand curve. And actually did know that competition law was a specialist issue and that you didn't simply move seamlessly from a road accident fund case to a competition law case the next day. In other words, it's kind of a bit difficult, is it not, to actually have to deal with question of, say, as to whether in fact the motorist was negligent to dealing with the question of predatory pricing. They have slightly different demands. And so I call the firms, the partners of the firms who do competition law, not once, twice, over a period of time. And on the second occasion, which is why I wanted to mention this, on the second occasion, they all arrived, and Paul Kutzer, who was then running the competition sidebar, whatever it was called, committee, kindly organized a meeting at Worksons where he was partner. And of course, bearing in mind that one is the judge president, it's hardly likely that these particular partners were going to turn around and tell me to go away. So they all came. And we had a long conversation about briefing patterns. There were some really bizarre remarks made by some people. One particular prominent competition lawyer told me when I suggested that we should be more diverse in our briefing patterns, because at the end of the day, my concern, apart from representativity, was that over the long haul, I wanted to make sure that we had a number of competition judges drawn who were demographically representative of the whole country. And how was it ever going to happen if we were perpetuating the same kind of patriarchal white system of the past? And one of them sort of said to me, but Judge President, we don't know all these traps. To which I said, actually, I'm not only talking about traps, I'm also talking about women, which really kind of, you can just imagine the climate. And so they were all umming and ahhing. And Robert Lee, who was there, and I think was chairman of Bowman's at the time, and therefore brought a sort of both moral and legal stature and physical stature to the entire proceedings, had said nothing. And then he said to me, Judge, you're absolutely right. And we've had a conversation about this at Bowman's because we're also worried about this. And let me give you this undertaking, that in our firm going forward, unless clients absolutely object to the composition of the team, we will have a women or black lawyer in our litigation team which argues these cases going forward. And that was a remarkable intervention because all the others then fell into line. And I desperately admired Robert both for his principle and for his understanding of exactly what is required if South Africa is to become a non-racial, non-sexist democracy. And it's in memory of him, therefore, that I deliver this particular talk to you today. Now, the problem that I face is that competition law, and Derek has made the point, and he's right to make the point, competition law, if it was an inflection point in 2019, is certainly at an even greater inflection point in 2022. When I started teaching competition law, and I was particularly influenced in this regard by Professor Eleanor Fox, one would really talk about two, perhaps three models of competition law that existed. The first one, the obvious one, particularly since we were coming out of the 1990s, was the Chicago School. And effectively, the concern was essentially with prices and output. And that essentially was conflated with the definition of consumer welfare. The European model, which at that particular point in time was being pushed by Mario Monti, another of the remarkable European commissioners who have been in office, was very much about what I suppose one would call the competitive process. The idea being that what competition law was about was to ensure and facilitate a competitive process in which entry and exit were equally possible, and that therefore you did not have a kind of agglomeration of power which was concentrated in perpetuity and therefore reinforced an economic status quo. And the process model, of course, was what demarcated, if you could put it this way, the debates that were taking place across the Atlantic between the American competition situation and that in Europe. And then there was a third model, very nascent at the time, not particularly well announced, but there it was, which you could call, if you wish, as I used to say to my students, competition process plus. And it was there that they were starting to nibble at the edges, issues beyond just competitive process. The kind of things that today we broadly put under the rubric of public interest. And that particular third model, which essentially was encapsulated in express terms by the public interest concerns under mergers in the South African Act of 1998, at that point in time, was very much an outlier. And I remember particularly addressing the plenary session of the OECD, and Frederic Genie had asked me to come to talk to these plenary session about public interest questions in competition law. And I remember going to this massive hall with delegations from all over the world. And with one or two exceptions, they thought I was completely nuts when I was actually talking about the public interest concerns that effectively were contained within the South African legislation. Roll on 22 years, and that's the debate now. And we can't get out of that debate. The debate is, what is the appropriate normative framework for competition law in general, but in our case, for developing countries in particular? And that's the really fundamental question. Let me make this point, which I don't have time to develop. I want to argue that we've never really developed that in South Africa. Partly my fault, perhaps, having authored so many judgments. Why we haven't done it? Well, we can talk about that if you wish. But the point matter is that, broadly speaking, that hasn't occurred. And it's fascinating to me that right across the world now, there are now conversations about whether that third model, nascent as it was in the 1990s, is now one where we have to consider it to a far greater extent than previously was the case. And in preparation for this particular talk, I went to reread a whole bunch of stuff which I'd taught and read before, but I just wanted to have another look at it. And I'm particularly referring here, amongst other things, to an article. She's written many things, and I have read most of them, but just a short article, which was written about a year and a half ago by Lena Khan, who now, of course, has gravitated a rather more powerful position than me being a student at Yale University when she wrote a famous article. And of course, Lena Khan is equated to a large degree with the neo-Brandeisian school of competition law. But it is interesting to me, and this is a segue into what I want to talk about in relation to these broad questions. It's interesting to me what she says and what she doesn't say. What do I mean by that? She starts off by talking about the fact that anti-monopoly law, and she's really conflating that, if you wish, with competition law, is a key tool, she says, and philosophical underpinning for structuring society on a democratic foundation. Recalling the words of neo-Brandeisian in 2012, she says, when he asked, what does democracy involve? Not merely political and religious liberty, but industrial liberty also. The Madisonian concept of self-government hinges on the ability of citizens to control and check private concentrations of economic power. Surrendering this ability, Brandeis noted, would mean that there is a power in this country of a few men so great as to be supreme over the law. And the first proposition, therefore, that the Brandeis and now the neo-Brandeis school are arguing is that the structure of the economy is inextricably linked to the democracy of the country. I hardly need to tell a South African audience how true that is. Question isn't the truth. The question is, how far does competition law play in dealing with this particular problem? And there lies the rub. Because even Lena Khan, in the development of her article, says, when we deal with anti-monopoly questions, this is far more than antitrust. In other words, the second proposition she advances, and rightly so, recalling, if you wish, both the dicta in the Competition Tribunal and the Competition Appeal Court in the Walmart case, which I suppose you could really say started all the trouble, is that competition law cannot change the world. That competition law is one tool in a broad toolbox of dealing with questions of structural concentration and the conflation, as it were, of economic and political democracy. And so her caution is that even in the United States of America, there were at its best a whole range of institutions which were designed to deal with this broader question, of which the competition authorities were merely one. And she then goes on to say that, of course, anti-monopoly does not mean that big is bad. And that's not an unimportant consideration either. You can't just simply conflate the one with the other. One's got to be very careful about how one interrogates that, she argues. Finally, and not insignificantly, she says the following. The Chicago School focused on consumer welfare as such. And this has warped America's anti-monopoly regime by leading both enforcers and courts to focus mainly on promoting efficiency, on the theory that this will result in low prices for consumers. The fixation on efficiency, in turn, has largely blinded enforcers to many of the harms caused by undue market power, including on workers, suppliers, innovation, independent entrepreneurs, all harms that Congress intended for the antitrust laws to prevent. The resulting system is so warped that enforcement efforts geared around consumer welfare have, according to important recent studies, resulted in higher prices and markups, meaning this philosophy fails even by its own standards. And then she continues, contrary to how critics portray the neo-Brandeisians, this school of thought does not promote using antitrust law to achieve a different set of social objectives, such as more jobs or less inequality. Doing so would replicate a key mistake of the Chicago School, overriding a structural inquiry about process and power with one that focuses on a narrow set of outcomes. I want to emphasize that. Yeah? She says, you don't want to make the same mistake as Chicago did by overriding a structural inquiry about process and power with one that focuses on a narrow set of outcomes. Refocusing antitrust and structures in a broad set of measures to assess market power can return the law to focusing on the competitive process. Now, it's that context with which I want to address, in the time available to me, some of the concerns about how far competition law should extend within the African continent in general. But the truth about it is there are a whole lot of people in this room who know more about other parts of Africa than I do, including my ex-student, one of my best PhD students I ever had, Dr. Willard Mwebi from the Zambian Competition Authority, of whom I said last night, why doesn't he come and take over the South African Competition Authority? It wouldn't be a bad idea. But what I want to talk about is in general terms. So what she's saying is this: let's leave aside questions of freedom, democracy, etc. She's saying those are broad issues, but they're not necessarily competition questions. They are the broader overarching issues that we have to deal with. And by the way, en passant, if I may mention, that in relation to questions of structure and power, part of the design of the Constitution was effectively to render both public and private power accountable. That's why the whole debate about horizontality in the Constitution was such a fraught and interesting debate all those years ago. And of course, we know that the Constitutional Court has hardly embraced the real challenges thereof. But if you are even remotely cognizant of the school of critical realism, started in the United States of America, but taken other places, you will know that all sorts of law, contract law, property law, delict, all have massive effects on structural concerns in an economy reproducing a particular economic status quo. And I mention this only for one reason: that to use competition law as your main source to address this is a fatal mistake and overreaches in extreme circumstances, having polycentric consequences, use the fuller term, which competition authorities cannot predict. That's the take-home point. Now, how then did public interest develop? Well, everybody quotes the Walmart case. So maybe it's not a bad idea in a conference struggling to look at public interest and balancing all these competing objectives to just for 2 minutes traverse what in essence that particular case was all about. And there are a few take-home points there too. You will recall, of course, that the problem with Walmart in the first place was that there were no, as it were, cognizable competition questions. No one was suggesting that output would be depressed if Walmart took 51% of Massmart. Secondly, no one was suggesting that prices would go up. Walmart brags all about the lowest prices. And I remember having a long debate with counsel in court saying, take a simple proposition of poor people having, because of our school uniform policy, that they have to buy a white shirt for their child. Now, if they could buy the white shirt for 10 at Walmart, but the rest of the places were charging it at 12, the fact that they could now get it at 10 was, of course, an extraordinary advantage to poor consumers. So those issues were never really in play. What was in play was the fact that when you looked at the overarching structure, to what extent did you have to give weight to public interest considerations? And if you read the judgment and the evidence carefully, then a couple of consequences emerge. In the first place, the two concerns, that is standard SLC on the one hand, and public interest on the other, are inextricably linked. Contrary to what is happening today, and I'll get there, public interest isn't some free-floating idea. It's not an invitation to rent seeking, either by the minister or the commission. It's supposed to be part of an integrative inquiry. In fact, one of the big issues in the Walmart, and ironically, one that was pushed by the now chief economist to the Competition Commission, James Hodge, who was then the union economist, right, was to argue, could you balance the, let's say, advantages to consumer welfare by the concerns I've spoken about? That's the price decrease or the output increase, to the potential evisceration of small and medium-sized enterprises, because Walmart would have a global value chain, which would ultimately work to the prejudice of small South African producers. And James Hodge heroically tried to do precisely that. We read a significant amount of evidence about seeking to balance these two issues, because he knew well then, and he was right, that this was an integrative approach, that you had to deal with both. That is, even though you dealt with this SLC, you still had to then deal with the public interest in the broader inquiry. And that was absolutely central to the Walmart case. There was another issue about the Walmart case, which I should also add, was the extent to which, leave aside the public interest, what content were you going to give to substantially lessening or preventing of competition? Were you going to simply attribute to it the barometer of price and output? Were you going to deal with the question of the competitive process? Or were you going to actually look at the very normative framework of competition law to build into the initial inquiry a whole range of concerns which you could call social and political concerns in the broadest sense of that word? Now, we cautiously did not deal with that, partly because when you're a judge, you've got enough problems on your hands, and you just try to deal with the case in terms of getting the best result you can without, contrary to what academics think, having to pontificate about a whole range of issues which are utterly irrelevant to the disposition of the case. But it always worried me. And when I went back to have a look at what I'd written in Walmart, there were quite a number of passages dealing with this particular question of what, in fact, consumer welfare meant. And a great deal of reference to some really thoughtful writing at the time by a German competition economist, Wolfgang Kerber, whose work, by the way, if you get it, is always worth reading. But I'll leave that aside. Walmart did not argue that public interest was some self-standing concept which absolutely had to be taken separately from the broader inquiry. The two had to be looked at together. And after all, if you look at the Act, that's clear. What you look at, you may prohibit a merger for public interest grounds. You may attach a whole series of conditions thereto, but you're doing so in terms of an overall inquiry. And what has happened, it seems to me, within the South African context, is a couple of things. Number one, we've added to our act in a whole range of issues. And of course, there are some African countries who've included public interest concerns in the abuse of dominance issues. And let me say this about that. That is certainly where the issue of what, in fact, the purpose of competition law is. That's where it comes home. Because abuse of dominance certainly needs to look at the structural questions to which Lena Khan referred. And there's a battery of literature which would support that particular proposition. But it's not easy. And it can't just be done in a sloppy and non-integrative way. But to return for the moment to the question of public interest, it's obvious to me that what has happened within the public interest domain in South Africa is there's no integrative approach at all. There seems to be a sort of bargaining in which somebody wishes to do a merger, and then to a large degree what happens is that, well, let's deal with public interest, let's extract some conditions. Why? Because that's what the Act says. How? Well, don't worry about the broader issues. And think about how absurd that is. Because when you look even at questions of employment, you've got to ask yourself, are you looking at it through a short-term lens or a long-term lens? What's the effect of the merger long term? We're supposed to do that anyway, aren't we? Because when we look at questions of merger control, we're generally interested in that because we're worried about what the merger might do in respect of unilateral coordinated effects. We're interested in what this will have on the structure of the market as it exists, and you're peering backwards and forwards for that purpose. But you're sure as goodness, in this particular instance, looking at the merger as a whole and what the effects would be. And therefore, one's got to be very careful by just simply tacking on a series of short-term concerns and arguing, one, that's congruent with the Act, and two, that gets you a more transformative competition vision. Because if you look, and I did a search of recent public interest conditions imposed by the South African Competition Tribunal, I have a whole list. I'm not going to bore you with them all, right? But let me just give you some. I won't mention the names of the companies, but I'm happy to do so if you want me to. Right? There's one which says, well, there's one, ShopRite. They must endeavor, in line with its proposed expansion plans for the trademarks, to open outlets operated by a franchisee and a trademark's name over the next 5 years, subject to economic conditions. Well, I'd like to know to what extent that, for example, I can assure you, what wasn't done there was any integrative analysis as to what the effect of the merger is going to be. And then you get the next one. Commission, the merging parties agree to a condition that the merged entity will continue to supply third-party customers of the one company on market-related items. Another one, provide financial and other support to an HDP-owned gas transport company entering the market for specific specialty gases and provide technical advice and support to an HD-owned potential provider of carbon dioxide related to the establishment of a carbon dioxide panel. The acquiring group, in another one, has committed to entering into a triple BEE transaction with the triple BE investment partner. The triple BE transaction results in investment partner having a specified percentage shareholding. That comes up over and over and over again. Now ask myself, I know that part of the Competition Act talks about the spread of ownership, and particularly to historically disadvantaged persons. And I think that's true. It's something, as part of the drafting team, I'm proud that we had. But what was the purpose of that? Was it simply to say, oh, well, we allow the merger, but you give 25% of the shares to XYZ? Or was it to actually say, a la Walmart, we're really concerned that if this merger goes ahead, there will be significant effects on small and medium-sized businesses, in particularly those owned by historically disadvantaged persons. Because it seems to me, you go through this list I have over and over again, the question of attaching, Commission found that there would be a dilution of ownership by historically disadvantaged persons at the company. To address this concern, parties agreed to conditions to maintain a certain level. I am totally in favor of the transformation of the economy. We don't have that, as I think Brandeis makes the point, you won't have political democracy in South Africa. That's obvious. The question is this the role of competition law? And more important, is this the role of the merger inquiry without a comprehensive analysis into all the factors which then give you a basis by which to deal with the public interest concerns? Recall that in the Walmart case, which of course is cited over and over again, the reason we came up with these conditions was because after an analysis of the entire merger, we had concluded that there was a real possibility that because Walmart would essentially look to its global value chain for various inputs into its business, and because it could get it cheaper in other parts of the world, then all of these other large retailers, such as Pick n Pay and ShopRite, Checkers and Woolworths and Spar, would follow suit to the detriment of small business in South Africa, to the detriment of the growth of small business in South Africa, and ultimately and obviously to the detriment of the transformation of this economy, which is absolutely imperative to ensure that it represents broadly the demography of South Africa. But that emerged out of a serious inquiry. This wasn't some sort of bargaining chip that you say, okay, we'll do this if you give me A. That's not what competition law is about. And when I go back to Lena Khan's point, if you're going to worry about short-term outcomes, absent the broader structural concerns, you don't transform the economy. You just rearrange the deck chairs on the Titanic. And that's why I say that we have to a large extent, and I'm running out of time and I had another half an hour to go, but don't worry, I know we've got to finish before 9 and I will, I promise. Terrible to have judges having to constrain their time. Much we do it the other way around. We tell counsel you've only got another 5 minutes, which, by the way, generally doesn't really help. The point I'm simply making is that what worries me is we do not have a serious guideline as to what we're doing, either in relation to mergers or in relation to abuse, to which I've just had peripheral reference. So let me make one final point about abuse, and then I want just for 5 minutes to end by just talking about the implications of Mediclinic, which is not an unimportant consideration looming large here. What I wanted to say about abuse is that when the amendments to the Act came in, the Minister wanted them. A number of us said to the Minister, how far do we go here? Because what we should be interested in doing is ensuring the most vigorous implementation of a process model to ensure that all forms of obstacles created by the structure of the South African economy, as it were, be loosened, so that in fact, instead of perpetuating a status quo, which has got us into terrible trouble at the moment, V-Day our growth rates, which nobody in this world actually thinks going to go above 2%. I challenge you all to tell me that the Minister of Finance in the budget next week will say anything more than that. And I'm probably being optimistic at 2%. And I say this in sadness, not with any glee. But the point I'm simply making is that to actually think through how we actually use competition law in the abuse sections to loosen up, as it were, the constraints on the economy and prevent people from entering it and prevent them from participating properly. That's the challenge. And what worries me is I don't think we even got there with the pre-2019 amendments. So the question is, it's not a question of amending, it's a question of actually thinking through what is the normative framework which is going to inform the inquiry in the first place, which of course circles back to my earlier point of public interest. Now, I could, and I think if we don't have a debate about this in serious ways, and that's why some of the other African countries which have used, I noticed Botswana, which has some rather kind of clear guidelines in relation to abuse in public interest. Well, that's interesting. I'm not sure you need those if you actually can interpret the concepts of competition law in a manner as I've tried to indicate. The Austro-Marxist economist Karl Renner, almost a century ago, said that the real issue in changes of law is you don't change the concepts, you change the content. And what he meant by that was that it's hard to dream up different concepts of law. It's the question of what content you put into those concepts of law, which is what I'm really making a plea for. So let me end, because it's on the same theme, with the Mediclinic decision. Well, two things or three things. First, I invite you to read the judgment of Judge Rogers compared to the majority judgment in the Constitutional Court. If you read Judge Rogers' judgment, in typical Judge Rogers style, because he's an extraordinarily meticulous and thoughtful judge, you have a serious analysis of the market, of what the geographic and product markets are. You then have a conclusion that once you've got to that point, what pressures of a price or quality of medical service are there? And he does, in this regard, look at Section 27 of the Constitution to say, does that in any way tilt the balance? It's an evidentially based judgment saying at the end of the day, there are not SLC questions. And he does that on the basis of evidence. If you look at the majority judgment, because there is a minority judgment too in the Constitutional Court, there's some absolutely extraordinary propositions. There's this question of, well, why was Judge Rogers worried about market power? The judgment is obsessed by market power, accuses the majority of the Constitutional Court. No? There's no, there might be a price increase here and there, therefore there's an LLC question. Well, we all know, if you know anything about competition law, particularly when I admitted to the earlier questions of unilateral and coordinated effects, what we worried about in mergers is, in fact, whether there'll be a change in the power structures of the market. That's the whole point. And for the highest court in the land to eschew any such consideration and use it against the judgment, well, that just puts our merger law into a catastrophic sphere of uncertainty. But it goes further. Because, and here is the one point that I support the judgment completely, it does emphasize the importance of the Constitution in Section 27. Let me say this, that when many years earlier, we were confronted with the possibility of the Treatment Action Campaign bringing a competition challenge to antiretroviral drugs, I couldn't wait for that. Great sadness that it never got to us, because it seemed to me that there was a case where you did your competition analysis, but if there was a debate about the interpretation, a debate about the implications, you had to take the right to healthcare into account in a very careful way, as indicated under Section 39(2) of the Constitution. So I'm all in favor of that. But that's not what now has happened. What has happened is, it seems to me that Section 27 now is used as a trump card. You don't have to worry about any of the evidence. Oh, Section 27 applies. Bingo. We have now arrived at the jurisprudence of that wonderful Australian film called The Castle, where effectively, you may recall, those of you who know, when some counsel who's helping this man try to protect his property and knows nothing about constitutional law is asked by the court, well, what section of the Constitution do you rely on in order to say the property should be expropriated? And he turns around and says, it's the vibe. And we've now reached the vibe. And so now what happens, from my information, is that in every case, the Competition Commission seizes on the constitutional question, absent a rigorous competition analysis, of which Section 27 must be a part. And so the only point I want to make, since I'm out of time, is that this, therefore, brings me back to the beginning of my talk, which is, I'm totally in favor of a reconsideration of competition objectives way beyond the question of the Chicago School. I agree with Lena Khan that there's structural questions that we have to address, which is where the inquiry should be informed. But that requires an analysis of the economic evidence. It requires an understanding of what is the objective of competition law. It requires a situation that competition law does not, as it were, should not be used as the tool, to quote Khan, to address inequality and jobs as such. Of course, by virtue of, in fact, having a progressive competition law, inequality will, in fact, be redressed in the long run, because the fact of the matter is you'll change the structure of the economy. But that requires hard yards. It doesn't require the vibe, and it certainly doesn't require the idea of simply looking at a first port of call at the public interest considerations, absent a rigorous understanding of the entire process of a merger, or alternatively of the practice of the dominant firm, to indicate that in fact those public interest concerns are triggered and in fact override what might be more tangible, traditional, cognizable competition considerations. That for me is a massive challenge ahead of us. But if we do not solve this one, our law will continue, as it were, to descend into a morass of uncertainty, which is not just going to be disadvantageous for investment, and Derek, you're right on that, it also is going to be disadvantageous for the broader nature of the South African economy, which has to work, must work, and we have to get it to work for 60 million South Africans, most of whom today are not just historically disadvantaged, they're presently disadvantaged. And that is a disgrace after 27 years of democracy. Thank you.